Partition, right? No, I'm not going to sugarcoat anything. We're diving in. Partition. We're going to talk about what it is, how is it possible? Can you buy out interest? Can you get quit claims from the interest of the title owners? But what's this concept? When can you use it? When does it really come up? It's just such an interesting topic. So again, if you don't know me, my name's Alan Nicoletti. Welcome. You're going to enjoy it. You can find me on Facebook. You'll find me on YouTube, my YouTube channel at Alan Nicoletti. That's where you can find me. But this concept of partition, we're going to cover and go in depth. Of course, I got to give my disclaimer and tell you that this PowerPoint presentation video does not provide legal advice, nor does it create any attorney-client relationship. The matters discussed here in this presentation video are informational and for educational purposes only. So I gave it to you. Let's dive in. So what is partition in terms of real estate? So what happens normally is you'll have people, forget husband and wife for right now, but you'll have situations of brother, sister, partner and partner, not just LLC, but partner and partner, A and B. Keep it very simple. You'll have people that will buy property together. It can be me and Jonathan, or me and Malachi, or me and Brett, right? Or just say two people go into a deal, or it's family that you're going with. You have a situation where people all of a sudden don't get along, right? 10 years ago, the deal made a lot of sense. Everybody's happy. Everybody's jumping around. We're making a lot of money with the property. Now, all of a sudden, the tune has changed. And somebody realizes that it's not worth it and we need to unload this. But then you have somebody that's in the property that just doesn't want to leave, right? You'll have somebody that says, I've been here forever. I've been paying the taxes. I've been paying the insurance. Or they just want to not squat. I don't want to say squat, but like they really do want to squat. They just don't want to leave. They're not productive to the property. So eventually you have a situation where somebody wants to sell and somebody doesn't want to sell. And in the Florida statutes, there arises this ability where two people or one or more can divide the real estate among the owners. So among a division among the title, people on title, okay? And under the statutes, there is allowed a lawsuit where one can go to an attorney and file a lawsuit to force the sale from the other or others. So even if it's just one person or the other, there could be 5 people on title and one wants to sell and 4 don't. 4 want to sell and 1 doesn't. But it's the ability of those heirs or people, it doesn't have to be heirs. It could be ex-husband, ex-wife. But the ability of those people to do a lawsuit is this partition, the lawsuit to end co-ownership and force a sale. They are able to file this lawsuit. And hey, Alma, and the basics is you get a judge eventually to sign an order that splits the property, not take a chainsaw and cut the property in half, but push it to a public auction, push it to a private sale. And the money at the end is divided up. It's a crazy concept. Many had no idea it even existed, and it's been around for years. I mean, this has been around many years. So the basic of it is 2 or more people on title own the real estate. Forget the husband and wife part. Don't think husband and wife. We'll get to that exception. Of course, in law, there's an exception to an exception, not a surprise. But you have co-tenants, joint tenants. So co-tenants could be A, B, C. I have a deed. I'll show you. We'll kind of go through it. But co-tenants, A, B, C, and D. You can have joint tenants, which joint tenants is just the language of the deed is a little different. You can have heirs versus heirs. So you can have a probate, mom died, there's 4 kids, and one wants to sell and the 3 others don't. Probate's not done. So of course, what do you know? You got to get the probate, you got to do the probate, you do the probate, and then you take there's the next step of this partition. So that's available. But you have one or more people want to sell and the other says no. That's what you're hearing, right? So many of you are either going to, at this point, mind blown, or going to be mind blown at some point down the presentation about, wait a second, Al, how many deals have I come across since I started investing where I thought everybody had to be on the contract? Oh, I thought everybody had to agree. Well, yes, to close, everybody, it's recommended, it's nice, it's great. But nobody said that there weren't creative solutions, right? Of course, that the money and the equity make sense. We'll talk, run for the hills is, of course, the slide at the end. I always put that on there. But the concept that somebody can do this and file a suit to force the sale to push it to a public auction, a private sale, a private auction, a public auction, there's different ways this goes. So it's allowed for co-tenants. Like I said, it's allowed for joint tenants. It's allowed for heirs against heirs, ex-husband, ex-wife. So why ex-husband, ex-wife? Matt, what is up, man? Matt and I have talked about this so many times. And I'm so happy he's joining, or he's going to watch this later, whatever. Matt, I'm so happy you're on. Ex-husband, ex-wife. So I get that question a lot. When is it time for a partition? A husband and wife property can be partitioned if it's in a divorce proceeding. It can't be partitioned other than that. Once the divorce is over and a final judgment is entered, then and the property is not contemplated in that final judgment, well, now that severed the husband and wife tenancy. So what was husband and wife is not husband and wife anymore. It's ex-husband, ex-wife. That now makes it a co-tenant. So that ex-husband, ex-wife fits in that co-tenant that you see. So now ex-husband, if you approach ex-husband, he wants to sell. Yeah, I want to sell. You approach ex-wife. No, I'm not on this earth. And now you have a situation where the partition can really fit in. So you're thinking about that stuff, right? Heirs against heirs. Like I said, you could, the probate could be already done. Maybe it's not done. Usually they're already done and everybody's fighting. Nobody can agree. But I've seen the other way. I've seen so many times where the probate's not even done and they can't get past the probate part. And now they can't even broach the partition situation. So just think through these scenarios. Is it going to work every time? No, because you got to think of the equity and the money and does the situation make sense? But is it a potential solution or creative solution? Absolutely. So post-divorce, again, I kind of just covered that. You're looking for realtors that are watching or will watch or whatever, realtors usually come across the divorce leads, or like on the foreclosuresdaily.com leads that are out there. You'll see the divorce leads. Are they already in divorce? Probably. Are they already done? Who knows? But when you're looking at the divorce leads and they're finalized and the house is not mentioned, now you create that tenants in common. So many stories and situations that come across this. So sometimes the probate doesn't work, right? So Matt, Brett, George, Alma, you all may come across a property where you run title and title says John is alive and the heirs and devisees of Sally. And then you run with the attorney, the probate attorney, you run through the whole scenario of the estate of Sally, and it's an absolute disaster. I mean, you don't want to spend the money on the genealogist. You don't want to spend the money anywhere. You don't know where everybody is. It's going to be a disaster. So let's say that happens and there's just nobody. Or there's an heir on that side. There's a niece, there's a nephew that is adamant about not signing, not selling. Well, what's your other route? I mean, if you can't get him to agree, do you just run the other way? I mean, you look at the numbers. You look at the numbers and say, does a partition make sense here? Can we go to John? Can we go to Johnny and say, hey, can we file? Can we do this suit? Do you want to do it, or you, the investor? We'll talk about that. Is it possible to do a partition to force the sale from the other? That's a scenario. It's a crazy scenario. Happened almost a year and a half ago. And what is it happened? That's why I even have this here, where the other person was deceased and one of the heirs was just not there. Cannot find the heirs. So go with the same story, right? Two people on title, A and B. Let's just say you don't want to do the genealogist search, or it doesn't make sense to do it for the other heir. Some people want to, some people don't. But you have an option where if that person's alive, they can force the sale from B. I have a crazy story, a hypothetical that kind of happened, and there was just a husband and wife. Husband conveyed it to an LLC, and the lady had died, and they weren't sure if there were minors or not. Well, anyway, brother was sitting on this property, and nobody knew who the heirs were for the other side. So what do? And this is an option to do this partition. You find out what works, and you try to see title wise, can we do this? 3 owners alive, 1 is dead, 2 is alive. Had this one, lady was in her late 90s. There were 3 kids. One of them was also deceased. But when you did the math, there was like 10 to 20 nieces and nephews. So on a probate level, I don't know if that makes a whole lot of sense. I don't know. It depends on the numbers. But know that this is a creative solution to say, okay, there's 2 people. One wants to sell. The others are, you can't find them. There's too many. Is the partition a better route to go on something like this? You got to work it out. You have to see title wise, money wise, cost wise, does this make sense? And that's what happened. It really depends. There wasn't money in that deal. There's got to be equity in the partition for it to work. The numbers can't be like this. You have to have a really good spread, probably a spread over 25,000. You're looking at a really good spread for the numbers. So here's a great example, right? So don't look at John Smith, because John Smith gave his interest to A, B, C, and D. So you have co-tenants here. Co-tenants A, B, C, and D. Malachi, thanks, man. I appreciate that. A, B, C, and D. So let's just say George approaches A. He wants to sell. B, he wants to sell. C, he wants to sell, but D does not. There's no magic language of anything in there, nothing preventing it. There's nothing to say that A, B, C can force a sale from D, or the scenario at the end of the PowerPoint, which is why everybody's sticking around, is A, B, and C quit claiming it to the investor, and then the investor handling the partition lawsuit. Crazy. Everybody's going to be paying attention now. So then go to joint tenants, same kind of concept, right? Because what did I talk about before? Where is partition allowed? Co-tenants and joint tenants. So on the deed, you'll see A, B, C, and D as joint tenants with the rights of survivorship. So you can go to A wants to sell. I see you, True. I know. I see the mind moving. A, B, C, right? But D doesn't want to sell. There's a partition could be allowed because this is what it says under the statute. So you're always looking for these things. You're always looking. Now I got to give you the exceptions, right? So husband and wife. Again, partition is not allowed for a husband and wife. So if you're married right now and you're looking at your spouse going, I'm going to force a sale from you, good luck. But if there's a divorce and you're going through a divorce proceeding, I've seen it before. One is hard timing the other doesn't want to sell. And so in the divorce proceedings, they can make a claim for partition. So if you see the deed, the quitclaim deed, it says A, B as husband and wife tenancy. You're out, right? So don't think that, oh, everybody that's married right now can force a sale from each other. It's not that. It's not like that. So you're looking for like the divorce proceeding, divorce judgment, judge sign. You're looking for that. Now, another exception to partitions and the forcing of a sale of property is the life estate deed, the ladybird deed. Everybody knows I talk about this when it comes to the probate world, right? So in the probate world, we've had so many of these situations. Husband is the only one on the deed. He's married. He also has children. He dies. Spouse thinks I'm automatically entitled to that property. Not so fast. She's not on the deed. Remember what I've talked about with probate. It's all about title. If she's not on the title, she still has to do a probate. Not to say that she wouldn't be not entitled to it, but she still has to do some kind of probate proceeding to get her interest. It's weird because in probate with homestead, if a homestead property, she gets an election up to 6 months since date of death. She either can take a 50% interest in the property with the other 50% to the kids, or a life estate in the property, meaning she owns it for her life, then to children. The difference is she only gets 6 months since date of death. If she chooses the life estate, there's no partition allowed ever. Not from the remainderman, not from the life estate. But it's a tricky situation, right? Because the wife is going to say, well, I want to live in this till I die. The other side, if she makes the election for 50% and then 50% to the kids, if she makes that in time, she can then, once that's done, do a partition after that. So just know that if you get those with the life estate, it's not happening. There's case law out there that talks about that. I know many of you will find those. So I've seen them before. I've seen them all year, and they come up once in a while. So let's see. And I have this slide here because I want people to realize that with partition, it's not about majority. There can be 5 people on, let's go 3 people on title. 3 people on title. One wants to sell and the other 2 don't. It's not about majority. It's just one wants to sell and the others don't. It could be 5 people on title. One wants to sell and 4 don't. It could be 14 people on title. One wants to sell, 13 don't. Now start getting a little weary of 14 people, because Mr. Al is going to tell you that the costs are going to be really high when you start getting more people, because now you have a chance of more people are dead, more people are missing. Now we have to start doing the affidavits of due diligence. It gets expensive. So don't necessarily get excited with more people. Doesn't mean it's more fun, and doesn't mean it's a lot faster either and cheaper. I've seen 42 people before. Not to say I mean, look, that's a lot and you have no idea what you're going to uncover. But the point is it goes to basics. There could be 42 people on title. One wants to sell and 41 don't. It's the same concept over and over. If they are co-tenants, joint tenants, it's possible. Okay? So what happens in this partition, right? So whether it's you, the investor, we'll talk about that, or them, A, B, C, and D, if they're the ones doing it, whoever's doing it, the idea is that a lawsuit is filed formally in the courthouse. We serve everybody, okay? Everybody's served. And eventually, if nobody responds or nobody argues, it goes to a judgment in the court, and the judge reviews everything, eventually signs it. And then it's going to maybe a public auction, okay? It can go just like the foreclosures and the tax deeds. It'll go to just like that. Or maybe it's an agreement of the parties, or the court will allow a private sale. Usually it will go to a public auction, because at a public auction, maybe you can buy it back. Maybe you can buy it back for a lot less. I don't know. With the public auctions they have nowadays, who knows how high it goes. But the idea is that with partitions, it can go several different ways. Partitions usually go the public auction route. But when I say this, I know when Al talks, Al makes it sound simple on this end, because it's like, oh, that's it. It's a process. I mean, this is not a quick process. It's not a 2 to 4 day special. This is not like a 1 to 3 week special. It's a lawsuit. So it takes its course, and it's got to get judge approved. But eventually you're getting somewhere. You're getting somewhere with the partition. Of course, there are defenses to a partition. Partition is allowed as a matter of statute. It's allowed. But there can be defenses to the partition. Meaning, so let's say one wants to sell and the other 4 don't. What happens when the other 4 have been paying the taxes, the mortgage, the insurance? I mean, you better believe they're going to make some kind of claim. And if they don't, they're defaulted. Okay, fine. But they're probably going to make a claim. Don, hey, thanks for joining, Don. They're going to make a claim. So it's always important to ask that question of, has anybody been contributing? Because it's going to be called an equitable distribution out at the end for those people that have been paying. And so it can be a defense to not the forcing of the sale, but the money being divided at the end, if that makes sense. So all of these things, it could be parties may be entitled to reimbursements, right? Mortgage payments, improvements, somebody keeping the other out. I saw that one, boyfriend, girlfriend. Girlfriend was like, oh, boyfriend's keeping everybody out. Ouster, repairs, taxes, insurance, other expenses. But it's something to always find out. You can't just let that sit. You have to find out exactly what's happening as far as keeping track of everything. So can a partition be waived or prevented? It can. If you've ever seen a land trust agreement, land trust agreements have clauses. And there's one clause that talks about partition. And it says that the property, the beneficiaries agree that the property shall not be partitioned. It shall not be divided. And there's good public policy argument, obviously, for that, for anonymity. But there can be times where even in a deed, it says agreement against partition. So now everybody's more smart about partition. If you go into a partnership, do you put that clause in? Who knows? It's up to everybody who does that. But if you see that somewhere and you see the parties agree that it shall not be partitioned, then you know that this is not happening, or a waiver, or partners of a partnership agreement. But you have to see what happens on title. You have to see what happens and who's agreed to what. True, I see your question. We'll get it at the end. So basic bottom line, forcing the sale. 2 or 1 or more people, it doesn't have to be 2. 1 or more people, or 2 or more people own the real estate, not just 1. You can't force a sale from yourself. Yeah, 2 or more people own real estate, okay? 1 wants to sell, the other doesn't want to sell. Okay, 1 says no. One of them can file a lawsuit from the other. That's it, before we get to the quick claim method. But that's it. Don't make it more complicated. It is straightforward. It's just something where you're looking for those red flags that come up, right? You're looking for those situations where somebody wants to sell and somebody doesn't want to sell. That's it. Now, I hope as many people as possible are paying attention. And if you are not right now and you're just watching this later, this is kind of interesting. Let's just say those title owners don't want to deal with the property. And the partition, and they don't want to deal with the property either, but they don't want to deal with doing a lawsuit. Okay. Hypothetically and theoretically, what if the investor buys out the interest of the co-tenants? What if the investor gets quit claims and or title insurance for that portion of that title, and then retains the attorney to force the sale from the property from the others? Wheels are spinning, right? So what happens? It's possible buying out the interests of the co-tenant and the investor doing the lawsuit to force the sale, whether it's a 1/4 interest. I don't know why I have 2 1/4s. It should be like 1/2, 1/4, 1/8, or the ex-husband's interest or the ex-wife's interests, and then just forcing the sale from there. These are possible routes if you run the numbers correctly, right? It all sounds great, but the numbers got to make sense. And then obviously everybody's got to have a meeting of the minds to agree that this can happen. But the option is out there. The option to solving this problem. And you how many people, I don't know if everybody wants to comment, how many people have been through so many situations? I know, George, you like that one. How many people have been through situations where one wants to sell? Let's just make it simple, but apply it to everything you got. One wants to sell and the other doesn't. Like, drop a comment. I'm just really curious. How many people have been through that situation? One wants to sell and the other doesn't. But the other person that really wants to sell never takes the next step, or they don't want to file the lawsuit. I mean, I'm really curious, whether it's now or later, it doesn't matter. I'm really curious to how many people that happened to, because this slide alone could be the golden nugget. Could it work? Could the numbers work? I even heard a situation that was really interesting today, where the ARV was like $300,000 on a property. And there's like 2 people, one agrees, the other doesn't want to agree, whatever. And it sounds like one of them just wants to give up their interest. So what happens if you just approach them and say, I'll throw you, I don't know, $15,000 for your half, and then you're the one that handles the partition, and then you're looking at probably a big spread. You're looking at a big spread if you push it to a public auction. When you get a quit claim or you get an interest, there's no guarantee of getting the property, even if you're the one on the end. So A, B, and C handle the partition. You don't buy out the quit claim. There's no guarantee you get the property. You can buy it back at the public auction. But in this situation, if you buy it for whatever number you can come up with that makes sense, you can try to buy it back at public auction. But if one of those behemoth hedge funds come into the state of Florida and outbid you by $20,000, well, forget the property. You're looking at the cash. So it's just something to really think about with what can you do with the buying out of interests. I'm probably going to turn a light bulb on with people at Yellowbird, with people in the People's Wholesalers. I'm sure Cash Geeks at some point is going to jump in and go, wait, what? But things like this can be possible. Think of ways to solve the problem if the money makes sense. Now, if you have a property, right, You have a property where ARV is 240, but the mortgage is 200. That's really tough, right? The person that's got the mortgage, it's a heavy load. Unless you reduce that by so much, it's going to be tough, right? Those are tough situations. But what happens? What happens when you get a property? There's multiple people on title. 4 of them are dead. One's alive, and then the other's alive, but those 2 don't get along. Can you buy out the other? Do you want to force the sale? All of this is possible if the money and the numbers make sense. So again, here's the situation. What happens with co-tenants? You have A, B, C, and D. Could you buy out A? So A wants to sell, but he doesn't want to deal with the lawsuit. B wants to sell, but he doesn't want to deal with the lawsuit. C wants to sell, but he doesn't want to deal with the lawsuit. Why not approach and say, do you want to convey your portions and you'll handle the suit? It's all out there. All of this is out there. Joint tenants, but you can't do this stuff. You can't do the life estate. That's not happening. So when it comes to some of this stuff, and if anybody at the end wants me to back up, I can always back up. But when it comes to partitions, there are fees and costs, just like a quiet title. It's not cheap, and it's not inexpensive. And it's not going to be a 2 to 4 day special. There are going to be costs, and fees for a partition can wait until the end, but the costs are going to add up. The more people there are, the more dead people there are, even more the alive people there are. There may be missing people. Who knows? But just know, just like in quiet titles, costs are expenses that are not going to an attorney. Attorney's fees is for all the work we do, all the time we spend. Those things, if you're the client, those things come out of the sale, and any costs are reimbursable back. So it comes off the top of the sale. It's really interesting, really unique. I'll back up. Fees and costs can be paid out of the proceeds of the sale, and the person that put forward the cost can be reimbursed back, borne out from everyone. So where in the world can you find some of these partition leads? Inheritance leads, right? So what are inheritance leads? Inheritance leads are the probate's already done. So mom died. There's 3 kids. You already did the probate attorney did the exact thing that they had to do, got the order. Now titles in 1, 2, and 3. Okay. That's an inheritance lead. Probate's done. Now title is in everybody. Divorce leads after divorce, not during divorce. Remember, during divorce, it's still iffy. So it's not really up for grabs, really. Pre-probate. What's pre-probate? Mom died, 3 kids, no probate's been done. So it's not been through the court process of a probate. Probate, it's already been in probate. So now you're looking at, is the orders entered? What's going on? I'll say this. This may get a little murky. I don't know. You may not need a partition if there's a probate situation going on. For example, forget about homestead. I know I talked to death about homestead, but let's just use land. Land cannot be homestead property. So in land, if there needs to be a sale, there needs to be an order authorizing sale that the title company needs. If we needed to get that order, do we have to do partition if one of them doesn't agree? Not necessarily. There may be a way in the probate that we petition the court to get a sale or an order. They may require more CMAs, comprehensive CMAs, appraisals. But in a probate situation, you don't always need a partition. It's when you have the ones where it's homestead property or orders of summary where title's already put in everybody. It all depends. It all depends on the probate situation. Foreclosure, you got to be mindful of where the property is in a foreclosure. If the foreclosure is deep and it's at like the summary judgment point, if it's already at the point where it's going to start going to sale, I don't know if a partition is really going to be timely or worth it at that point. If you get it really early on, maybe a partition at that point may be worth it, because now you can nip it at the bud. There's great argument for the judge to say, look, this needs to go to a private sale, not a public auction, because it needs to be retail value. It really depends on all of this stuff. That's why it's not a straight shot. This is going to work for everything. You got to evaluate when it works. So you can go get these lead lists on foreclosuresdaily.com, Liz Pendon's foreclosures, tax delinquencies, tax deed sale notices. I just have a whole bunch of stuff there. But so everybody knows this is one of my favorite slides in a probate presentation, because it all sounds great until you actually come across the situation, right? So when do we run for the hills? When do we run for the hills? When does it not make sense? The deal has to work for everybody. Seller, buyer, third buyer, title company, attorney. It's got to work for everyone, because there was a situation during the COVID stuff where there was a partition and everybody thought there was enough equity. The title checked out great. The situation checked out great. But you know what nobody checked out? How much money was left when the sellers are going to get their net sellers proceeds? Nobody really did a HUD breakdown. Yes, we'll get to title commitments, George. But you know something? It wasn't about title commitments for the partition. It's about the spread. It's about the amount of money. So this is just a lesson. It was a great lesson for me, but this is just a lesson that it's not just about the title commitment. For partitions, what you're looking for is always getting a HUD statement of the breakdown of net proceeds to seller. What is the spread looking for? Because if the numbers don't make sense, especially buying the quick claim, are you going to buy at fair market value? Probably not. But you will have to run the numbers and see what makes sense on the spread. It's almost like a wholesale in a way. Probably a better wholesale if you get the right deal, not such a small assignment fee. But the deal has to make sense for everyone. I've stressed that so many times with probate, because if one person, if the full wheel isn't on, it's not going to work. It's wobbly. It's going to come off, and it's not going to make sense. Somebody is going to not make sense. So, yes, what I tell everybody all the time, you have to do your due diligence. You have to always make sure before you do any quit claim, before you do any buying out, before you any partition, you always need to get a title commitment and a real breakdown of what title shows. Because with some of these properties, you'll find out there's so many quit claims. See it all the time. Quit claim, quit claim, quit claim, quit claim. Oh, we own the property. I don't know about that. I mean, I see it. I saw one the other day where they said, oh, it's one probate. It was like 3 or 4 at the end, because you have to check. You have to look. If you title is vital. And if you're not working with great title companies, I'm not a title company. I don't do closings. So I'm out. I'm out on the title part. I don't do title commitments. So always working with a great title company that's going to get you a commitment, that's going to get you the supporting docs, the supporting deeds, is very important. You have to make sure. And if you're doing that quick claim, see if from that title company, if you can get title insurance for that portion. Very important about all the protections and making sure title adds up correctly.